3 responses from the state in the YSL RICO trial were filed today. Yeah, I'm a little confused. I thought the cutoff for the state was Friday. That's what the judge said, I think. So I don't know how they're still filing shit today, right now. But they responded to Mr. Harvey's motion for a mistrial and Max Shart's motion to get rid of Woody's testimony in general. And then lastly, they want to make sure that Thug hands over all evidence, which is ironic because they failed to do that for a year and a half. So I get triggered towards the end of this video. I get so pissed off. At one point they say they want a fair trial. The state says that. What? What do you mean you want a fair trial, Miss Love? Are you real? You have done nothing but have a fair trial. I'm literally speechless. Hit subscribe. Here we go, boys. All right, first document we got right here is response in opposition to defendant Nichols' motion for mistrial and severance. So for some reason, the state only responded to this motion for a mistrial. The mid-trial substitution of a judge does not violate the 6th or 14th Amendment rights to a trial by jury. So clearly the state's going to disagree with this. I disagree with this. I don't think a judge can just hop in on a 19-month-long trial. She basically admitted she hasn't been following it, so she doesn't know anything. How is she going to rule on anything? Nichols says it violates his 6th and 14th Amendment rights. State says the mid-trial substitution of a judge does not violate the 6th Amendment or 14th Amendment rights. This claim was made in McIntyre v. State in 1995, and the Supreme Court of Georgia assumed, for purposes of this appeal only, that these rights are implicated by the mid-trial substitution of judges, and ultimately rejected the claim. However, when it did so, the court specifically referenced People v. Espinoza from 1992, in which the Supreme Court of California held that a mid-trial substitution of a judge does not violate those rights. Okay, so far the state is citing 2 cases from the 90s where courts basically say it's allowed for a new judge to come in. Concerns with directed verdict motions are unfounded. In paragraph 2, defendant Nichols asserts the mid-trial substitution is inappropriate because he claims it will affect his ability to request a directed verdict at the conclusion of the state's case in chief. This concern is unfounded. A directed verdict of acquittal is only available if the evidence is insufficient as a matter of law. Citing Boyd v. State, to overcome a motion for directed verdict, the state would direct the court's attention to admitted evidence which establishes the elements of guilt. Alright. Defendant Nichols asserts that the court advised the parties that she was unfamiliar with the previous trial proceedings and that this would affect the court's ability to rule on motions and objections. She did say that. I just said that. 30 seconds ago or whatever. Nichols says this violates his due process rights. Nichols' claims turn upon this court's familiarity with the case. Among those jurisdictions which have statutes regarding the mid-trial substitution of a trial judge, some require the new judge to certify their familiarity with the record. So they require the judge to basically read up on everything that's happened in the trial. How is that possible? It's been a year and a half. Any other judge of the court or properly assigned to that court, upon certifying in writing that he familiarized himself with the record of the trial, may proceed and finish the trial. Some jurisdictions don't even require them to do this, which is kind of crazy. But Georgia doesn't have a statute, though, that requires this. Georgia's primary case is McIntyre v. State. What if the replacement judge scrupulously review the prior proceedings and state on the record his or familiarity therewith so as to establish that the replacement judge is fully prepared to render informed rulings on any matters that might arise and to instruct the jury thoroughly? There's no authority requiring that within the Georgia law. The majority opinion itself in McIntyre leaves the matter to harmless error review. Regarding the constitutional aspect of Nichols' claims, the Supreme Courts of other states which have considered this issue have determined that the mid-trial substitution of a judge does not violate the defendant's constitutional due process rights, citing Peoples v. Rogers from 2009. This isn't open. I just tried to sip a soda that wasn't open. Neither the Constitution of the United States nor the Declaration of Rights demands more. Notably, both states with and without requirements that the replacement judge certify familiarity have denied such claims. Part of Nichols' arguments in the court is that they would have personal or direct observations of prior proceedings. If Nichols' arguments about personal or direct observations were correct, then no mid-trial replacement could ever be permitted. Given how well established it is that one judge can replace another judge during a trial, especially circumstances require it, these arguments are unfounded. Okay? The state sees no reason to believe that this very capable court is unable to rule appropriately on motion or objections moving forward. How easily available recordings of the trial proceedings are. Yeah, she's going to go back and watch 100 days of the trial. Jesus Christ. Some people have commented that she could watch my videos, but at this point I'm pretty biased towards Thug, like, because I just hate Miss Love and the state. The state is just corrupt, so I'm biased towards Thug at this point. I can't stay neutral. Georgia does not have a requirement that the court certify familiarity with the record. The state offers to do whatever it is within the power to assist the court in gaining appropriate familiarity. Temporary recess of a trial is not basis for a mistrial. Nichols moves for mistrial because of a month-long recess in proceedings. Nichols cites no case law in support of this claim. Indeed, a month-long recess, though unusual, is not unprecedented. In State v. Campbell, a month-long recess occurred during jury deliberations when a juror was in a car accident. Holy shit, they must have been really f***ed up in this car accident. A month long? State v. Antoine from 2000, defense counsel's illness prompted 2-month recess. The court should again deny the request for severance. I'm actually interested in why they would want to keep him on the case, considering he hasn't been brought up once, really. Nichols has just been coming to court for a year and a half, and he hasn't really been brought up yet. Defendant Nichols and his co-defendants are each charged with a violation of the Georgia RICO Act, in which the state alleges they engage in a conspiracy. Nichols' separate actions and those of his co-defendants are alleged in the indictment as overt acts of that conspiracy. These are not just separate but related crimes, but the same crime, the RICO conspiracy charge. The evidence against each is evidence against all. Previous defendants have raised similar motions for severance, and RICO prosecutors and the denial of their motions have been affirmed. So Miss Love's just saying, "F you, you're staying on the trial." All right. She cites a few cases, but whatever. Now we got state's response in opposition to defendant Stillwell's motion for reconsideration. Glanville's ruling that statements made by YSL gang member Damekion Garlington to fellow YSL gang member Kenneth Copeland are admissible to co-conspirator statements under OCGA 24-8-801 is proper and need to not be reconsidered. Ms. Love's basically saying, "Fuck you, we're not going to reconsider it. Therefore, this court should deny this thinly veiled attempt at de facto judge shopping because this court's prior ruling was in accordance with OCGA, blah, blah, blah. However, if this court is inclined to consider defendant Stillwell's motion, then the motion should be denied." Ms. Love is accusing Max Shart of judge shopping a ruling that's already been established by Glanville forever ago, letting Copeland's testimony come in as a co-conspirator statement and what Damekion Garlington said to him. Thugger Daily pointed out on Twitter that apparently Ms. Love is calling out Max Shart for judge shopping a ruling, but apparently she's done the same thing. So yet another example of Ms. Love being hypocritical. Statements made in furtherance of the conspiracy are not hearsay. Stillwell's argument ignores numerous facts and controlling legal principles. Most significantly, Stillwell fails to recognize that this is a gang and criminal enterprise prosecution. As such, the underlying conspiracy in question pertains not only to the murder of Mr. Thomas, but more broadly to the activities of the YSL criminal street gang. Therefore, the conspiracy in question continues today. YSL continues to exist and operate as a criminal street gang. All right. Miss Love really think there's people in YSL still out there doing dumb shit? Like, come on. There's no way. That right there is false. And Garlington's statements, better described as party admissions to Mr. Copeland, were in furtherance of that conspiracy. OCGA 24-801. Admissions shall not be excluded by the hearsay rule. An admission is not only defined as a party's own statement, but it is also defined as a statement made by a fellow co-conspirator during the course of a conspiracy. When a defendant is charged under the Gang Act with committing a crime in furtherance of the purposes of a criminal street gang, he may be part of two conspiracies: the immediate conspiracy to commit the crime and the larger criminal conspiracy to participate in the gang. Citing Chafers v. State, Georgia Supreme Court held that a declarant's statements were admissible under OCGA 24-801. Evidence showed that as a fellow member of the Rollin' 20s gang were part of a larger criminal conspiracy. Georgia courts draw their interpretation of this code section from the federal courts, which have reached the same conclusions on co-conspirator hearsay as the Georgia Supreme Court did in Kemp and Chavers. Statements made by co-defendants to other co-conspirators are admissible if they were made in furtherance of the YSL street gang conspiracy. 11th Circuit and Georgia courts apply a liberal standing in determining whether a statement is in furtherance of a conspiracy. So Max Shart said in his motion, Damekion spilling the beans to Woody is not in furtherance of the conspiracy, so that's what she's responding to now. To be admissible under this code section, a co-conspirator admission need not be necessary to complete this conspiracy, but must only further the interests of the conspiracy in some way. Statements between co-conspirators which provide reassurance, serve to maintain trust and cohesiveness among them or inform them each other of current status of the conspiracy further the ends of the conspiracy. Ooh. So informing each other of current status of the conspiracy kinda falls under what Damekion said to him, because what he said to him was they just killed Nut. But is anything Woody ever said to be true? Like, Woody is a liar. It's just a terrible witness for the state, no matter what way you look at it. Even boasting or bragging is furtherance of a conspiracy if the statements are directed at obtaining the confidence or allaying the suspicions of co-conspirators. A statement can also be in furtherance of a conspiracy when it is necessary to keep a co-conspirator abreast of the conspiracy's current status. Furthermore, narrative past events, however, are admissible under Rule 801 D2E if they serve some present purpose in the conspiracy. Glanville has stated, and the state has introduced evidence at trial that has proven to be preponderance that YSL is and was on January 10, 2015, a criminal street gang. The statement was made in the course of the conspiracy because, as in Kemp, the statement can be interpreted as fostering cohesiveness with another gang member, as proving information to a fellow co-conspirator of a criminal street gang's activity. In parentheses, the gang-motivated murder of Thomas and the gang-motivated shooting of Lil Wayne's bus. Within hours of the murder of Thomas, Copeland, along with other YSL gang members, fled the city of Atlanta and headed to Miami, Florida. I mean, that is a little hot boy to literally flee the state right after a shooting. That's not a good look. Multiple retaliatory shootings occurred between Inglewood Family Bloods and YSL Street Gang members in direct result of this murder. It was imperative for the sake of the YSL Street Gang that Mr. Copeland become aware of the circumstances of the murder so the YSL Street Gang could be on alert for retaliation. Oh my god. So Miss Love is providing another reason why it's admissible right here. A declaration against interest. To be admissible under this rule, a declarant must be unavailable. The statement so far tends to subject the declarant to criminal liability that a reasonable person in his position would not have made the statement unless he believed it to be true. The statement is corroborated by circumstances clearly indicating its trustworthiness. The Supreme Court, as previously explained, the logic behind this rule is founded on the common sense notion that reasonable people, even unreasonable people who are not especially honest, tend to make self-inculpatory statements unless they believe them to be true. Gullington's statement was a declaration against interest. Gullington's statement to Ms. Copeland admitting his knowledge about the murder, other crimes, and its perpetrators constituted a declaration against interest. Statement is self-inculpatory. Gullington had significant information about the gang-motivated crime. Gullington is a member of the same criminal conspiracy as those he named as the murderers and as the shooters in the incident involving Dwayne Carter. So they're saying just because of his position he's in, he has no reason to lie. So it's like a common sense approach. A declaration against interest. Courts have found that self-inculpatory statements are sufficient corroborated where the evidence presented at trial supports the veracity of the out-of-court statement and where the declarant makes the statement to someone with whom he shares a close relationship. Copeland and Gullington are members of YSL and share gang affiliations and have shared a close relationship for years. These conversations were not to law enforcement but amongst close gang members and friends. The context of the statements thus demonstrates their self-inculpatory nature and cooperation is under Rule 804b3. Therefore, the statement is not only admissible as a co-conspirator admission but is also admissible as a statement against interest. This court should deny Stillwell's motion to exclude the statement, blah, blah, blah. The Georgia rules of evidence, as well as their federal counterparts, specifically provide multiple means for Gullington statements to be admitted through Copeland's testimony. So last one, motion to compel defense compliance with reciprocal discovery obligations and to exclude any evidence intentionally withheld and not timely disclosed. What? Reciprocal discovery obligations. You're the state of Florida. Miss Love got some nerves, so she's gonna be all petty, be like, they need to follow the rules we're following. I hate Miss Love, dude. Miss Love, you are the state of Florida, and several times you have not handed over evidence, especially the Brady evidence at the ex parte meeting. On opening statements, you put an incorrect, false piece of information about Brian Steele in a slide. You never even turned over your slides when you were supposed to turn over your slides in opening statements, so it was blindsiding the defense. State began presentation of case in chief November 2023. They've been doing this shit. That's how long their case in chief has taken. Defendant Williams has repeatedly withheld from the state evidence in his possession even before the start of the trial until after the state began examining the witness through whom Defendant Williams sought to and was allowed to introduce. At the first known violation of Defendant Williams' discovery obligations, the state moved the court to compel the defendants to comply with OCGA 24-16-4. Williams argued that he has no duty to disclose any evidence to the state unless he begins case in chief for rebuttal. The trial court then denied the state's motion after noting that it appeared to the court defendant had no obligation to provide evidence to the state until after the state's case in chief. So this was already denied by Glanville. So this is what Thugger Daily was talking about. Miss Love is doing the same judge shopping here on a prior ruling. You already got your L, Miss Love. We can't go back on other rulings. That's what you said another time. We can't do that. No. A defendant has a duty to disclose prior to trial, an ongoing duty to timely disclose any evidence he intends to use as both impeachment evidence and as substantive evidence of innocence. Williams has repeatedly refused to comply with this reciprocal discovery obligation. Any further refusal by defendant Williams to timely disclose evidence warrant the extreme remedy of the exclusion of the evidence at trial. Isn't this ironic, Miss Love? You have the defense so many times, and Glanville has yelled at you about making sure everyone has the discovery. This is so ironic. Are you brain dead? Like, actually, is Miss Love brain dead? Does she have something wrong with her? She's done this several times. I've watched it 100 days of the trial. The state does not move the court to exclude every late piece of evidence that the defense may tender at trial. Indeed, the state did not move to exclude the extremely untimely evidence introduced by defendant Williams until it became apparent Williams was intentionally flouting his reciprocal discovery obligations. The state only asked that the court guarantee a fair trial for all parties. Isn't that ironic? Oh my God, she didn't just say that. The state of Florida just said that. The state only asked the court guarantee a fair trial. Hey, Miss Love, remember when you guys coerced Woody to testify? Remember that? The star witness, he didn't want to testify, but then you threatened him with jail time for years on end, and then he wanted to testify? Interesting. How's that a fair trial? Exclude any evidence tendered by the defense has been intentionally withheld. Oh, f you. So yeah, Miss Love's delusional like always, but tomorrow, or as this video is up, I'm going to be working on the next video. I'm going to have to double upload the day you see this. Tomorrow, they're going to go through all these motions in court, and it's going to be goddamn Avengers Endgame level. The trial could end tomorrow. I don't know what's gonna happen. You probably know the result at this point. Hit subscribe, follow me on Twitter and Instagram. Join the channel membership is only 10 cents per day. I appreciate the support so much. Love you guys. Peace out.